Good morning from me. I'm Jennifer Smith, Director of Government Relations. Today we're going to talk about Senate Bill 1108 and the Open Meetings Act and the changes that has made. Brad's going to go through that for you and take some of your questions. We will mute everyone so that there isn't background noise during the presentation. If you have a question as we go, please put it in the chat box and we will ask those as we go with Brad. We'll have some time at the end. Also, if there are questions, we're going to try to get through everything today. If we don't, then we can follow up later. So with that, I will turn it over to Brad to explain what's going on with OMA now.
All right, thanks, Jen. Appreciate the introduction. Good morning, everyone. I heard lots of good mornings when people were logging in here. A nice chilly October morning, as I like to say, the frost is on the pumpkin. So lots of upcoming changes for the Open Meetings Act, and that's what we're going to be covering here this morning. And I do have a PowerPoint slide or a PowerPoint presentation for you today. And that should now be on the screen. I did share this with Stacy. So this presentation will be available to everybody, okay? So you'll have this as a resource document after today's webinar, and you can kind of use it going forward. So let's get right into it. As I've been telling a lot of folks that I talk to over the phone that, well, these are very fluid times right now, and things change almost on a daily basis. And just to kind of give you a snapshot, where we've been for the last 6 months or so, we had 185 executive plus 185 plus executive orders since March. And then everyone is aware of the Supreme Court decision that was settled on October 2nd, making essentially the executive orders invalid that were issued after April 30th. Which meant that the order that allowed school boards to have virtual meetings was no longer valid. So you really didn't have any clear legal authority to have a virtual meeting after April 30th. And then quickly after that decision, you had some Department of Health and Service emergency orders that are still in effect. You had one issued that following Monday, and then one on the following Friday, which kind of added to the order that was issued on the 5th. And this order, which is still in effect today, provided authority for school boards to have in-person meetings. And that's been an issue throughout all of this, whether you could in fact have an in-person meeting. From the onset, it was clear you could have virtual meetings, and then as we got each executive order throughout the process, little by little, you were able to expand on your in-person meetings. So, as of today, you're permitted to have an in-person meeting, but that meeting's going to be subject to the attendance requirements of the DHS emergency orders. If you have a fixed seating venue, you can have up to 20% of the seating capacity, but no more than 500 individuals, except for Region 6 school districts. Upper Northern Michigan, Lower Peninsula, they can have 25% of the seating capacity for a school board meeting. If your venue doesn't have fixed seating, then your attendance is going to be limited to 20 people per 1,000 square feet. If you're in Region 6, that's going to be 25 individuals per 1,000 square feet. And so these are the in-person limitations that you're subject to. And of course, if you're having an in-person meeting, you're going to be subject to the requirement on face coverings as well as social distancing. Now, there is a exception to face coverings in the MDHS emergency order that permits an exception for someone giving a speech for broadcast or to an audience, provided that the audience is at least 6 feet away from the speaker. Now, I haven't seen any interpretations on this particular exception, but in my opinion, I think this exception would apply to a board meeting. Now, board members should still wear a face covering in attendance at the meeting while they're in a school building, but if you're talking during a meeting, at that time, I believe you may be able to temporarily remove your face covering from your nose and mouth, say what you need to say during that board meeting, and then apply the face covering back after you're finished speaking. Because of that, you may want to consider having all your votes be by show of hand votes rather than voice votes. That way you're not dealing with taking the face coverings on and off. So that's just a quick opinion on that issue that has been presented to me the last day or so. So I think that exception would apply. And if you have any follow-up questions on that, just let me know. So on that note, let's go ahead and get into Senate Bill 1108. Yes, Jen.
We do have one question regarding the masks. They wanted to know if that would apply to individuals offering public comments.
I think that would be a reasonable interpretation, that you have an individual addressing the board in person. That same person is speaking to an audience, whether it be the audience out in the board audience or the board itself. Yeah, I think a individual providing public comment could also remove his or her face covering, but you still have to respect social distancing. So you want to make sure that there is at least 6 feet of separation between someone giving public comment on the board and other members of the audience. Okay.
And then what if a board member refuses to wear a mask at all?
Well, that has come up, and with that issue, you consult with your local law enforcement. You consult with your county health department and see what the process is for enforcing someone who refuses to comply with the DHHS order. That violation of that order is, you could result in a criminal fine as well as a civil fine. And at the very least, I think someone could be charged for trespassing as well, not only in violating the emergency order. Because in order for someone to have the ability or the right to be on school property, you have to follow the law, you have to follow the policies to be on school property. And if someone refuses to follow that emergency order for political reasons, I would say that they're likely trespassing on school property, and your law enforcement may be able to assist with enforcing that trespass as well. Okay.
And the final one on masks. At one point there was a discussion about what is considered a face covering, a face shield, a cloth mask. Was that clarified in the DHHS order again, that it has to be a cloth mask and not a face shield?
It is not clarified in the order. The order only defines a face covering as, I can look this up really quick. Face covering means a covering that covers at least the nose and mouth. Okay, so it's something, as long as it's covering the nose and mouth, that would meet the definition of a face covering for the purposes of the emergency order. All right, we're going to go ahead and move along from face coverings and get into the details of Senate Bill number 1108. All right, so I'm just going to kind of give you a quick snapshot at the beginning, then we're going to get into the specifics of it. So when this bill is signed into law, and we know it will be, Jen has been in contact with the governor's office. She has been told that it's going to be signed. And we're very confident, pretty much 100%, that this is going to be signed into a law within the next couple days. So as soon as it's signed into law, before January 1, 2021, and retroactive to April 30th, 2020, that's very significant. You can have a full virtual meeting under any circumstances, okay? So there are going to be limitations to having a virtual meeting on or after January 1, 2021, but up until that point, and all the way back to April 30th, you're able to have a full virtual meeting for any reason, under any circumstances. So that retroactive language is significant. If maybe you're having a meeting Monday or Tuesday that may occur before this bill is actually signed. Now, I was hesitant to advise having a full virtual meeting when this bill was being considered and it wasn't approved by both chambers with the retroactive language. But now that it's been approved and we have this clear retroactive language, it's been approved by the Senate and the House and essentially enrolled and waiting for the governor's signature. I guess it's not in the possession of the governor yet. It's still in the process of getting sent to her. I'm confident, that it's going to be signed and it has this retroactive language. So if you have a meeting scheduled for Monday or Tuesday and this bill is not signed yet, I'm comfortable with advising that you may conduct that meeting virtually as long as it's in compliance with the requirements that we're going to take a look at in a minute. And once it's signed, that meeting automatically becomes legitimate, under law. Okay. I wasn't confident in advising this until the law was approved by both chambers. Now that it is, I'm comfortable with that guidance. And we'll get into this, the processes and the requirements you have to follow in a bit in having a full virtual meeting for the next couple of months. Now, after January 1 and through next year, 2021, December 31st, you're only going to be able to have a virtual meeting to accommodate absent board members due to military duty, a medical condition, which we'll look at the definition in a bit, or a statewide local state of emergency. So there's going to be limitations after December 31st here. And then after December 31st of next year, you will only have a virtual meeting, only have the ability to have a virtual meeting to accommodate board members due to military duty, which is essentially how the act read prior to this amendment. There may be some possible changes to this law during lame duck, and Jen can get into that a little bit later after my presentation. But when this is signed into law, after December 31st of 2021, you will only be able to have a virtual meeting to accommodate members of the military. All right, let's kind of get into a little bit more detail on some of those limitations. An electronic meeting permitted because of a state of emergency or state of disaster, you have the following limitations, and this will be after December 31st of this year. The electronic attendance is permitted only for a member of a school board who resides in that effective area. I mean, there could be a circumstance where a specific county declares a state of disaster, okay? Such as what happened up in the Midland area when they had their floods. And if that's the case, a member who resides in that area can participate virtually. Same thing with the full board. If the full board has traditionally held its meetings in the effective area that's impacted by that state of emergency, then the full board can have a virtual meeting under the state of disaster, state of emergency exception for virtual meetings. And then, if you are having an electronic meeting just to accommodate board members for military duty or a medical condition, only those members can participate remotely. Okay, that's significant. So you cannot have a full virtual meeting if one or two members are participating virtually due to a medical condition. Only those individuals can participate virtually. I'm going to go ahead and stop there, see if there are any questions, Jen.
Yes, we have a few.
Okay.
If the limit for capacity is, a 300-person auditorium, you have to be at 30%, so it's 100. What do you do with the 101st person?
Well, that's a great question. I think there's a couple of ways to address that. One would be having an overflow room, having an additional room in the school building where you can live stream that meeting. And then if that 101st person wishes to address the board in public comment, you can have that person come into the room and maybe another person leave, so you don't reach your maximum capacity. I think that's kind of the best practice for the situation. If you're unable to accommodate an unexpected large group, that's not going to automatically result in a violation of the Open Meetings Act. The Attorney General has provided guidance on this issue and has essentially indicated a school district or board must make its best efforts to accommodate a large group. It doesn't say you're definitely required to accommodate that large group, but you make the best efforts to accommodate that large group. So if there's no way to accommodate it, and the large group, then that 101st person could be excluded, for safety purposes in order to comply with the emergency order. But again, I think just having an overflow room with a virtual live stream would be the best practice, and that would be the best way to accommodate a large group.
One of the questions also was who can declare a state of emergency, and this is under state police, that a chief executive of a county or municipality can declare a local state of emergency and request assistance from the state. I don't believe that means a school board. Is that correct?
That is correct. Yep, and I think I do have a slide that kind of gets into a little bit more of that definition a little later.
Okay. After December 31, if there's a quorum physically present, can a person call in?
I'm sorry, Jen, say the first part of that question.
After December 31st of this year, could a person call in if there's a physical quorum present?
No. It would have to, according to the law, if we're still under, if there's a state of emergency, state of disaster, yes, that board member could call in. But if there's no state of emergency, no state of disaster, if that board member does not have a medical condition, or that board member is not missing the meeting because of military duty, that person cannot call in. And that's kind of a significant change. Why I arrive at that interpretation, the bill states, a board can have a virtual meeting in whole or in part under these very specific circumstances. And I interpret in part to mean individual board members participating virtually. And if an individual board member doesn't fit into one of those categories, that individual board member cannot participate in the meeting virtually. And I wouldn't even allow participation. No involvement in the meeting whatsoever virtually, as how I interpret the legislation at this point, unless you fit into one of those categories.
So if your board is there in person, could you still have a virtual option for attendance? There's been a few comments that virtual meeting attendance has been the highest ever. So could they have an in-person meeting combined with a virtual meeting?
Clearly, you can do that up until December 31st. After December 31st, I think you could certainly live stream your meetings, but if you're going to say, okay, you're participating in public comment, or you're satisfying the attendance requirement of someone attending a meeting under the Open Meetings Act by virtual means, that will be questionable. So at this point, I guess my answer to that, Jen, would be one-way live stream would be the best practice. And until we get further interpretations or further clarifications on this bill, I would still have individuals who are participating in public comment to be there in person. Okay, unless one of the exceptions applies, such as a state of emergency, state of disaster. And I might get a little bit more into that issue later in the outline as well.
There's a question about documentation for medical conditions, and this was included in one of the versions of the bill, but the final version that came out does not have documentation required.
Yeah. Again, I got a slide on that later, and we will address that one when we get to that slide.
And this sort of encompasses a lot of the questions being asked in different ways, but if you have a board policy that already accommodates for remote voting, does this bill void that policy?
I think it will after December 31st. Obviously, you're going to have to update your policies. MASB has been in communication with Neola, talking about how they're going to address the changes in the law, and you'll see an update on that within the next couple days.
All right. Well, why don't you continue, and we'll come back to some more questions in a little bit.
All right, sounds good. So, if the last slide here before we get into what your procedures for your upcoming virtual meetings, you must establish procedures to accommodate the absence of members due to a military duty. So prior to this legislation, you were required to have procedures to accommodate the absence of members just specific to a military duty. Now that's been expanded to cover not only military duty, but a medical condition or a statewide or local state of emergency. These procedures must allow an absent board member to participate and vote on business before the board. It must allow for two-way communication between the remote board member and the entire board and the community participating in that meeting. And this is a new requirement here. You must publicly announce at the beginning of the meeting that, and then documenting this in the minutes, that a board member is attending remotely. Now this only applies after December 31st, okay? So after December 31st, if you have individuals participating virtually because of a military duty, medical condition, or statewide or local state of emergency or state of disaster, you have to publicly announce that someone is participating remotely, and that must be documented in the minutes. And then the announcement must also identify where that individual is specifically located by stating the individual's county, city, or township and state. Does not apply to someone who's absent due to a military duty. This was a little bit of a tweak as the bill was progressing through the legislature. At first, they had an exception in regard to someone having a medical condition. Then they changed that exception to military duty. So if someone is missing a meeting because of a medical condition, they're participating remotely, they still have to indicate where they're participating from, county, city, township, village, or state, but does not apply, obviously, to someone who's been deployed for military duty. And then the procedures, lastly, must indicate how a member of the public can contact absent board members and provide input on any business to the board member that will be coming before the board at the upcoming meeting. These are the definitions I referred to previously. So you see medical condition, pretty broad definition here. Illness, injury, disability, or other health-related condition. As Jen mentioned, when this bill was passed in the Senate, originally had a requirement for documentation for the medical condition. That has been removed. So as a board president, superintendent, you don't have to worry about seeking documentation from a board member who wishes to participate remotely because of a medical condition. And then, as Jen mentioned earlier, you also see the expanded definition of statewide or local state of emergency or state of disaster declared pursuant to law or charter by the governor or local official or local governing body that would risk the personal health or safety of the members of the public or the public body if the meeting were held in person. Now, before we get into the specifics of your virtual meetings that you'll have moving forward, any questions, Jen?
Is age considered a medical condition?
Well, I think because you don't have medical documentation here required, I think this is going to be somewhat subjective. And I know with age comes many health-related conditions. So that last part of the definition, or health-related condition, I think arguably could cover age. It's hard to argue that someone who's advanced in age doesn't have any health-related conditions, and that's going to be subjective to that person, in my opinion.
A couple other medical questions. Could a medical condition include a family member has a medical condition? So it's not my condition, but it's someone else's. I don't want to catch and transmit COVID back to my house. And what about someone who is just paranoid of COVID?
Well, on the first one, I think it has to be the board member with the medical condition. I don't think it can be a familial relationship as far as claiming that medical condition. So it has to be the individual board member. And then someone who's just paranoid, again, a very broad definition of what constitutes a health-related condition. I'm not a doctor, but paranoia may be a health-related condition. But I will defer to the doctors on that.
And just to be clear, one of the questions is, does the condition have to be related to risk for COVID? And the bill does not say that.
No, it doesn't.
It's medical condition.
Yep. So again, very broad definition. And, if you look at legislative intent, because there was language in there that originally required documentation, now it's been taken out. To me, that really broadens the definition of medical condition. So, I'm not sure if you're going to have many board presidents or superintendents out there who are going to be challenging board members on whether they have a medical condition that prevents them from attending a board meeting in person. I think there's probably going to be a lot of leeway, a lot of discretion on that matter. So any more, Jen?
Stepping away from medical, if an ISD is appointing a new board member, can those interviews be held virtually, or do those also have to follow these rules under 1108?
I think up until December 31st, those interviews can be held virtually under the Open Meetings Act. It simply says if you're conducting an interview of public official, that must be done in open session. Because this is going to allow virtual meetings to constitute open meetings under the Open Meetings Act. Those interviews up until December 31st may be conducted virtually.
Okay.
Can we move on and cover some later? Okay.
Yep.
All right. Now these are the requirements that you're going to have to follow next week when you conduct your first virtual meeting under this new law. So your virtual meetings must be conducted in a manner that permit two-way communication. Now you're going to see that a lot of these requirements were the same requirements that were in Executive Order 154. So these are going to look very familiar to you. The board members can hear and be heard by other school board members, obviously, and then your public participants can hear members of the school board and can be heard by the school board and other members of the community when they are engaging in public comment. This is significant as well because I've received a number of questions about this issue during the process of board members having virtual meetings. So as a school board, under the new law here, you may use technology, and I emphasize may, use technology to facilitate typed public comments during the meeting. Now that's the change from Executive Order 154. Previously, that language wasn't in there. So now if you choose to allow written comments to be submitted to the board for your public comment session of your board meeting, that has to occur during the meeting. Okay, so emails should be sent, messages should be sent during the meeting, not prior to the meeting if you're going to be using written comments in place of in-person comments during a virtual meeting, which could be conducted virtually and in person at the same time. So yeah, I know a lot of boards have struggled with that issue of having written comments during the meeting. So you may want to move away from that and just say if you are going to address the board, you have to do it in real time, where we're no longer accepting written comments. To me, that really has kind of complicated public comment a little bit, but if your board is comfortable with that process and it's worked well with your board while having virtual meetings, by all means, continue it. But just know that it's discretionary, it's not required. It is a decision that, may be up for debate with the entire board, and there may even, should be a board decision on whether you're going to use written comments for public comments during a virtual meeting. And then board members participating electronically in a meeting that occurs at a physical place, they're considered present and in attendance at that meeting. So your minutes don't have to say board member was participating remotely. Now that will change as of December 31st, but from now until December 31st, if someone's participating remotely, they're as if they're physically there in the meeting, and you don't have to state in the minutes that that person is participating remotely. Notice, you must follow the special meeting notice requirements here of 18 hours in advance of the meeting. So if you're holding a virtual meeting, you have to post notice on your website 18 hours before that virtual meeting. It must be on a web page that's fully accessible to the public. So if you're using board docs, board book, and that's password protected, you want to make sure that you have an area on board docs or board book that if you're using that for notice, that is fully accessible. Or you just may want to create a separate page or link from board docs or board book that would take someone to the notice. If the notice is not on the landing page of your website, you need a prominent and conspicuous link. See here an example I give you in the PowerPoint, that a prominent and conspicuous link would say public notice for an electronic school board meeting. That would go to a separate web page dedicated to public notices for special meetings or electronic meetings. So 18-hour requirement here, same as the posting requirement that you have for normal special meetings. What must that notice indicate? Again, these elements are very similar to what you would have experienced if you were obviously having virtual meetings under Executive Order 154. Why is the school board meeting electronically? Simply because of the pandemic. How are members of the public able to participate in the meeting? Here you would have the link, to your Zoom or whatever meeting platform you're using, so people can simply click on the link to access the meeting. Or if you're doing it telephonically, then you would have them connect to the meeting by telephone. How members of the public may contact members of the school board. So a contact email page that people may submit questions or request contact information about an individual board member or board members, so they can communicate with that individual prior to the board meeting. And then your ADA statement, anyone with a disability, how do you make that virtual meeting accessible to the individual with a disability? Have a way that someone can contact the school district to request accommodations in order to participate in the virtual meeting. So you must have this notice, must be on your web page or website and fully accessible. Let's cover agendas, and then we'll take time for any questions that may have been presented the last couple slides. So this is new. This was not part of Executive Order 154. So if you have an agenda for an electronic meeting, you must make that agenda available at least 2 hours before the virtual meeting, and it must be on the district's website if your website includes monthly or more frequent updates of meeting agendas or minutes. So I've been on a lot of school district websites, and I traditionally go to the board page, and most of your Board of Education pages do have a page or on that page, there's information about agendas and meeting minutes. So I'm going to say probably 99% of our boards likely have a page that includes monthly or more frequent updates on meeting agendas. So you want to make sure that your virtual meeting agenda is posted there 2 hours before the meeting begins, okay? And this is something you want to do next week. If you're having a virtual meeting on Monday and you haven't been doing this, you want to make sure that that agenda gets posted 2 hours before the meeting. Third bullet point's important. Even though you've posted this agenda, does not mean you're unable to amend it at the meeting. So if you have the process of approving your agenda prior to getting into the business of the meeting, at that point, if someone makes a motion to amend the agenda, that's fine. No issue there, even though it's been posted publicly on your website. Any questions, Jim?
I'm sorry, I couldn't get unmuted. Let's see. So if someone puts their name as anonymous on a written comment, on a written public comment, does that need to be read and added to the minutes?
Well, that's a great question and kind of relates to the slide I just pulled up here. So you're not able to require a person to register or provide his or her name or other information as a condition of attending the meeting, okay? I have attending emphasized because I think you have to distinguish that from someone participating in public comment. This provision goes on to say that a board may establish and require mechanisms relating to signing up for and participating in the public comment period of the school board. So, and to me, this is probably going to be the provision of the law that is subject to most questions and may be subject to a lot of interpretations as well. But the way I'm interpreting the language is that you can require folks to sign up and register ahead of time before the meeting is called to order, and they should provide their name as a way of signing up to address the board, and I would limit it at that. I would not require address or anything else beside the name, because I think you need to identify the individual for when it's time for public comment, you call on that person. You would unmute that person and say, Sally Smith, you're now up for public comment. So I think for virtual meetings, you can require someone to identify him or herself, and you can require that that person sign up ahead of time. That's my opinion at the moment. I suppose that could change based upon how maybe the Attorney General or there's additional clarification on this particular requirement. Now, this only applies to virtual meetings. If you're having an in-person meeting, my opinion, if someone shows up for an in-person meeting and if they want to address the board in person, they have a right to do that. They don't have to identify themselves, and they don't have to give their address or anything like that. But in the interest of avoiding any type of Zoom bombing, anything like that, you can require folks to sign up in advance, be identified by name, and if they don't sign up in advance, they don't have the opportunity to address the board. To me, that's how this language should be interpreted, because the legislature just simply could have left it as you can't require a person to register or provide his or her name or other information as a condition of attending the meeting. And if it was just left at that, I think you wouldn't be able to require someone signing up in advance, but because they say, they refer to being able to establish and require mechanisms relating to someone participating in public comment, I think you can require that. And if someone does not sign up in advance, they don't have a right to address the board.
So under the Return to Learn law, boards have to vote on their continuity of learning plans once a month, and it requires comments. So if it is a virtual meeting, the written and I guess spoken public comments need to be considered and included, correct?
Yeah, that is correct. You know, that provision in the State Aid Act, you know, does say, you know, when you're reconfirming your extended learning plan, at that meeting, you must solicit comments from the public. So what I've been recommending on that is you may want to present your plan right off the bat at that meeting, and then allow for public comment, whether it be on the extended learning plan or anything else within the jurisdiction of the board, and then vote to reconfirm the plan after the public comment. I don't interpret the language in the State Act to require 2 opportunities for public comment. I think you can still limit it to 1 if you wish, but I would advise that you have the public comment prior to reconfirming your extended learning plan.
And if people are submitting comments, this would be virtually throughout the meeting, like today, where we've got the chat box running, but it is outside the public comment period. Do those have to be acknowledged?
No. There's case law that supports a board enforcing its public comment rule of only allowing public comment at a certain point of the meeting. Once you've passed that point of the meeting, you don't have to permit any more public comment. Again, it's supported by a Court of Appeals case. Certainly you could allow that, not sure if you'd want to, but yeah, once public comment is over, no one has the opportunity to address the board at that point.
I'm going to combine these two. How do you conduct a closed session under this legislation? And what about ADA? Is there something regarding ADA that they need to consider with this?
So ADA, the issue on that is just that you have to give notice on how someone can participate in a meeting if they need accommodations. And beyond that, I'm not sure what else a district would do. Just wait for someone to request accommodations. And maybe a best practice though that you're always using closed caption without anybody requesting that, so you have the ability for closed caption. But again, make sure you follow the requirement of allowing someone to contact the district to request accommodations for accessibility. I got a slide later on closed meetings, so I'll address the closed meeting issue when we get to that slide.
It's best practice to track who's present at a meeting for contact tracing. Would that be okay? So I think the question here is like some sort of sign-in or to know who's in the building.
Yeah, I mean, the law doesn't get into that. I think you could establish that as a rule for contact tracing. So yeah, I don't have any issue if you wish to have a sign-up sheet for people attending the meeting for contact tracing purposes.
I mean, you may have said this, but does reaffirmation of the extended learning plan require a vote? The answer to that is yes. That was included in the Return to Learn law that was signed in August.
Yes.
I think we're caught up.
All right, sounds good. Well, let's move along. And here's our slide on closed meetings. The law does clarify that members of the general public who are participating in a virtual meeting do not have the ability to attend a closed session, obviously. And as long as you're holding that meeting under the requirements of the Open Meetings Act. However, you're not allowed to have a closed meeting without having an open meeting first. Okay, so you have to have an open meeting in order to vote to go into closed session. I know it would be super convenient if you were able to just say, okay, we're having a closed meeting. Thus, we don't have to put out any notice about that. We don't have the ability, we don't have to worry about public comment or public attendance, but unfortunately that's not the case. So if you're having a virtual closed meeting, you have to first convene an open meeting, allow public comment at that meeting, and then you can vote to go into closed session at that virtual meeting. As far as how to go about having a virtual closed meeting, I've heard from other districts, they have a breakout room. If you're using Zoom, I know Zoom has breakout room capability, and they have a separate breakout room for closed meetings. In guidance that I have issued, I think at one point I suggested maybe you should just make that closed meeting accessible by telephone and only to the board members and members of the administrative staff who are participating in that closed meeting. And I know folks have concern about, well, how do we know that that person participating virtually is alone and the closed meeting is going to be confidential? All that you can, as a board president, you can, emphasize, we're going into closed session. You got to make sure that you're in an area that is, going to keep the closed session discussion confidential. No one should be able to hear our conversations. Maybe if you have headphones, put on headphones while we're conducting this closed session. There are a number of, proactive steps you can take to ensure the confidentiality of that closed session. But ultimately, it comes down to trusting your fellow board members and ensuring that they're going to respect the confidentiality of closed sessions, and just the board member will be participating in that closed session remotely, and they won't allow any other individuals to have access virtually to that closed session. Because we're on closed session, just take a quick look of when you can have a closed session under the Open Meetings Act. You see the 8 reasons for that. The first couple of reasons require a request from the individual who is subject to discipline or the evaluation that the board is conducting. Discussing collective bargaining strategy. I know a lot of your districts are now, or if they haven't been engaged in collective bargaining, we'll be beginning that soon in the next couple of months. So you can go into closed session for collective bargaining strategy. Considering the purchase or lease of property, not selling property, but only purchasing property. And note the asterisk, that notes a 2/3 vote. So closed session reasons 4 through 8, you have to have a 2/3 vote in order to go into closed session. Number 5, I've highlighted specific pending litigation because of recent case law. You have to identify the court case that you're going into closed session to discuss. You can't simply say going into closed session for pending litigation. You have to specifically identify that pending litigation. Number 6 essentially applies to when a board is conducting a superintendent search. I advise be careful of exceeding the scope of that closed session. It's only for reviewing applications. You can't make any decisions in that closed session, such as narrowing the pool of applicants, determining who the board's going to interview. It has to be very limited as far as how a board uses that closed session exception for a superintendent search. Number 7, essentially your attorney-client privilege exception. It has to be, under that exception, it has to be a written opinion from your attorney in order to go into closed session. It can't be an oral opinion. It has to be written because FOIA specifically exempts a written opinion from public disclosure, and because that written opinion is exempt from public disclosure under FOIA, allows you to go into closed session under the Open Meetings Act to discuss that written opinion. And the last one, considering security planning to address existing threats or prevent potential threats. Now, I think the legislative intent behind this exception was to address, possible attacks on a school district, attack using firearms or something along those lines. But I think you could interpret this exception to cover a threat posed by COVID-19. So if there is a threat that needs to be addressed because of the pandemic, I believe this exception would apply, allowing the board to go into closed session to consider that threat and to address it, as long as you have the 2/3 voting requirement. So, with that, Jen, we're all I'm through with discussing Senate Bill 1108. I just wanted to quickly cover a few slides on emergency meetings. I've been getting more questions on emergency meetings because of the COVID-19 pandemic. Previously, I would recommend you're never going to have an emergency meeting, because the threshold for having an emergency meeting is so high. The circumstances are going to be extremely rare. But now we're kind of there right now. I mean, there are circumstances where because of an outbreak in a school district, a board must meet maybe to address that threat to the health, safety, and welfare of the school district. So I'd like to quickly go over the emergency meeting requirements of the Open Meetings Act. Under the provisions on emergency meetings, it doesn't require public notice or advance notice of the meeting. So how that would work, maybe the superintendent or the board president feels we need to meet immediately, okay? If we delay, it could possibly expand the outbreak or whatever the case may be. So we need to meet immediately. So board members are contacted, show up at the district building. And the very first thing on the agenda will be taking a 2/3 vote to determine whether delaying the meeting would be detrimental to the efforts to lessen or respond to the threat. That should be the very first vote that the board takes when it calls that meeting to order, okay? And if you don't get the 2/3 vote, so if you don't have 5 members of a 7-member board voting in the affirmative to have that emergency meeting, the meeting stops at that point. So it's technically not a meeting. But if you get the 5 votes, you can continue on with the meeting. You'll see some additional requirements here. Now you see the first bullet point. If the emergency meeting is held in person, then you have to have paper copies of the public notice of the emergency meeting available for the public at the in-person meeting. Now, the language of the Open Meetings Act doesn't cover a virtual emergency meeting, but I believe you could still have a virtual emergency meeting without public notice, advance public notice. But if it's a virtual meeting, I'm advising that the notice should be emailed to anyone who connects to the virtual meeting, or maybe have a link on your website that would connect someone to the notice of that meeting, okay? That's a best practice. Again, the law is silent on that one, but I think that would be the best way to comply with the actual requirement you see at the first bullet point. The notice must include an explanation of why the board could not comply with the 18-hour posted notice requirement. And you have to be specific to this. You just simply can't say, we needed to address an existing threat. No, you have to be more detailed than that, how you're going to address that threat and how that threat was going to cause harm, disruption, to your school district. The notice must also be posted on your website in the same manner as your special meeting postings. And then within 48 hours after holding that emergency meeting, you must send an official correspondence to your Board of County Commissioners, in which where the board is principally located, informing the commission that you had a meeting with less than 18 hours public notice. This communication can be delivered either by U.S. mail or in the same manner that the public notice was distributed at the meeting. So that's all I have. Any other questions, be happy to answer here during the webinar, or you can feel free to contact me by phone or by email, or contact Sharice Lee as well if I am unavailable. And I know I have a full inbox now of questions from earlier this week, so really appreciate everyone's patience. If I answered your question in the webinar and you sent me an email on it, please send me an email saying you answered my question. You don't need to respond to this email. That will save me a little bit of time. But at this point, Jen, I'd be happy to answer any outstanding questions here.
Okay, I'm going to go through a few more questions. Some of you have put in very specific examples of questions, and I'm going to leave those and get those to Brad after this to deal with the specific circumstances. And then after this, I will touch on some of the questions are about why did they do this? And I will touch on that once Brad's answered all your questions and a little bit of what we're looking at in lame duck on this issue. So just to clarify, If you are meeting face-to-face next week, do you advise against letting people Zoom into that meeting?
No, I don't advise that. I think you certainly can if you're meeting face to face. So if you're not going to comply with the virtual meeting requirements, and if it's a traditional face to face meeting, as if this legislation didn't exist, I would advise just a one-way streaming of that meeting. I would not advise allowing people to actively participate in the meeting if you're not going to follow the virtual meeting requirements, okay? If you're following the virtual meeting requirements, yes, then you could have a hybrid meeting where the board is physically present, but because of space limitations, you're not allowing the public to attend in person, then you follow the virtual meeting requirements that we just covered, and you allow for the interaction via virtual means by the community. But if you're not going to comply with those virtual meeting requirements, if it is a pure traditional in-person meeting, then I would recommend only one-way streaming, and then anyone who wishes to attend that meeting needs to attend in person.
We've been accepting written comments well ahead of the actual meeting, and they're read during public comment. Does the bill state that you can only accept public comments that are written during the meeting and you can't accept them ahead of time?
I mean, that's how I am interpreting it, Jen. I know there was a little bit of discussion on that issue, but because they added during the meeting, I mean, my thought is that those comments had to be made and submitted during the meeting. That I guess that's how I'm interpreting that language. You have any thoughts on that?
I know that that was an addition because we didn't want to have you forced to read every email that is sent to you. So include that language so that you didn't have to, but I don't know why, if you wanted to, you couldn't. But that language was specifically added at the request of MML and us, the Michigan Municipal League, because the concern was, we know you get a lot of emails and we didn't want you to feel like you had to read every single email you got on an agenda item.
Yeah, so maybe a good middle of the road approach on that would be, don't mandate it that it has to be submitted prior to the meeting, but it possibly could be submitted prior to the meeting. That may be one approach to it.
If you have someone, a member who is medically intolerant to wear a face covering, how do you proceed as a district?
Well, the current emergency order simply says you take their word for it. You don't have to require medical documentation on that individual. If you inquire into the individual's medical issue, you're risking an ADA issue or you're risking an ADA claim. So if someone simply says, I'm unable to wear a face covering due to medical reasons, you have to take that on its face.
If I'm sharing COVID data and updates as we track those, can those be emailed to all board members, or is that considered a violation of OMA?
If it's a one-way communication and if you're just sharing information with board members, that would be fine. What you don't want is to maybe have a deliberative process with the board after that information is shared. So, if someone responds by saying, wow, based upon these numbers, maybe we should consider closing this building and going to remote learning for this building, and that starts a deliberative process amongst the board members and the administration, discussing electronically that issue, that would be a problem. But if it's a one-way communication to the board, no issue with that.
Just to say it out loud one more time, if we're having a virtual meeting between this week and next week, are we in violation if the bill is not signed yet?
If the bill is not signed yet, right now you don't have the authority to have a virtual meeting. So if a board is concerned that this is not going to be signed, what I would recommend then is that you just follow the DHHS emergency order, have an in-person meeting at a venue that accommodates, at least 50 or so people in order to comply with the Open Meetings Act, or however many people you believe will show up at that meeting based upon your meeting data and how many people have attended in-person meetings in the past, and then you'd be fine. Then you don't have anything to worry about. But if circumstances really prevent your board from having an in-person meeting because of space limitations or health matters or whatever the issue or reason may be, then I think you can have a virtual meeting, because once this is signed into law, it becomes, you have the authority to do it. Okay, it automatically retroactively applies to that meeting, and there will be no question about what you did or what you accomplished at that meeting, whether it be in compliance with the Open Meetings Act or the votes that you took at that meeting. So yeah, I mean, that's kind of where we're at on that issue. It would have been nice if the bill was signed today, but we're not in that place. So that's the best advice I can give you at the moment.
So I'll speak to the signing of the bill. There's been a couple questions about that. We spoke with the governor's office yesterday. She will sign the bill as soon as it lands on her desk. We've been in contact with her since this started moving to make sure that would happen. I then reached out to the Senate Majority Leader's office, because it is the Senate that has to send that to her. There is a logistical process that has to be done. The bill has to be checked that all the I's are dotted, all the T's are crossed before it can be presented to the governor. And that is what's happening right now. Shirky's office, the Senate Majority Leader's office, is hopeful that they can get this done quickly. It is a priority on the list of all the bills that got done last week. So we're hopeful that she will have that bill on her desk by early next week. There's just no real way to rush it faster than that, with just the things that have to be done if this works. So we do expect her to sign it probably early to mid next week. It just depends on when that bill lands on her desk. Some of the other questions before we get back to that have come up is, why are we doing this? Like, why are we limiting participation? And I would agree that I've heard from so many of you that you have seen increased participation with these virtual meetings. But as we held hearings on these bills and the debate on the Senate and House floor, there is still a lack of trust out there with some of the legislators that just think that virtual meetings are a way for board members, and it's not just school board members, it's all board members, is a way for them to not have to face the public. And so a lot of education needs to be done of those members, and I would urge all of you to start doing that. We are going to try to take a run at some of the restrictions in this bill in lame duck to get them lifted. The restrictions such as ending virtual meetings on December 31st, we'd like to extend that into next year, as we know this pandemic is not going to suddenly end at the end of the calendar year. So we would like to get that pushed forward. And then some of the restrictions that will essentially end the ability to hold a virtual meeting by 2022, unless you're in the military. So these are conversations that we are having with both our friends in the cities, townships, counties, and other school organizations, and some of our friends in the legislature that are sympathetic to what we're looking for. The difficulty is the handful of legislators that just believe that you're looking for an out. So that's where your work comes in, is to contact your legislator, make sure they understand what you've been doing for the last 7 months, how it's worked for you, and that this has increased public participation. And I think that's what they need to hear. They talk about transparency and they talk about increased participation. And I think that if we can show that, and if you can show that locally, we'll get a lot farther. So we will take a run at that at lame duck. I'm not saying we'll be successful. I'm saying we're going to try. But as we wheel and deal in lame duck, we'll try to get this on the table as well. One of the other questions was about emergency orders, and the judge did strike all those down. So we currently are not under a state of emergency. The legislature has been asked if they're going to reinstate that, and they've been silent. We don't know for sure if we will go back under a statewide state of emergency, but right now we are not. Let me see if there's any further questions. I did just now got a text from my contact in the governor's office. They are pushing to try to get this signed over the weekend. But again, we just don't know for sure. There's logistics. So one of the final questions, there's just a handful of them left here, Brad. Do we have to follow MDHHS guidelines that all people entering into a school district have to wear a mask, that is required? I think this goes back to board members that don't want to, audience that doesn't want to, or those that claim they're medically intolerant.
Well, I mean, again, it's clear that these orders are enforceable, whether it be by a civil fine or a criminal fine or other criminal penalties. So in no way am I going to advise not to comply with the orders. And the orders do indicate, whoever is responsible for the gathering is responsible for enforcing face coverings at that gathering. But I think you still want to work with your local law enforcement. You want to work with your local county health department to come up with strategies, ideas on enforcing the face coverings. But again, you do have the exceptions. The one exception, and I mentioned earlier, about broadcasting to an audience or making a speech to an audience. I think that would apply to a school board meeting under limited circumstances. When someone is addressing the public or addressing the board, while they're speaking as a board member or speaking as a member of the public, and then obviously a individual not able to medically tolerate a mask, face covering, then you're not required to get documentation from that person. So yeah, I think you enforce it, but with taking into account those exceptions.
Can you allow board members to participate virtually, but require citizens to be present for participation?
I think up until December 31st, well, I don't know. I mean, that is a good question. So you're requiring members of the public to come in person, but you're conducting a virtual meeting with members of the board participating virtually. Now, I think that would be questionable. I wouldn't advise that. I mean, if your board members are participating virtually, I can't imagine, the public interest in saying, well, members of the public have to be there in person. To me, that would be interpreted as we don't want members of the public addressing the board. So we're going to require them to come in person while our board members are participating virtually. So yeah, I wouldn't recommend that.
What if it's a hybrid meeting and some of the board members are in person? Can you then require citizens that want to make public comment to be there physically present? When you have some board members virtual and some physically.
Yeah, I think, if you're doing the hybrid meeting and board members are going to be physically present, but you're still conducting a virtual meeting, I think you could require a individual to participate virtually in public comment. But if the virtual meeting the option is there, I don't believe you could say you have to come into the meeting to participate in public comment in person. I don't arrive at that interpretation. Obviously, though, if a board feels strongly about that issue and wishes to implement such a rule, I advise you contact your legal counsel and get a written opinion on it.
All right, I have two last questions, and then if your question was not answered, please know we will be going back through the chat box and getting answers to those questions. But two last questions for you, Brad.
Okay.
One is, if board members believe the meeting should be held virtually, but some believe it should be held in person, who makes the ultimate decision on how that meeting is held?
Well, that's a great question. I've always taken the position that a board member doesn't have, the independent individual right to participate in a meeting virtually. Now that was up until this legislation. And I still think that it's discretionary whether you want to have a virtual meeting. However, if it relates to virtual participation because of a military duty, because of a medical illness, or because of a state of disaster, state of emergency, then those individual board members, in my opinion, have a right to attend individually. Okay, whether it's going to be a full virtual meeting now until December 31st, I think that's a board issue. And I think one of the ways that you could possibly address, implementing these virtual meeting requirements is through a board resolution. And when the board passes that resolution, I think part of the discussion and maybe a separate motion would be, are we going to have virtual meetings now between now and December 31st? So in my opinion, it would be a full board issue unless the individual board member falls into one of those individual circumstances.
All right, and the last question deals specifically with COVID-19. And when you go places, you see signs that say, if you're sick, don't come in here.
Mm-hmm.
Are they allowed to temperature check, to COVID screen, just to ask the questions that you get asked when you go into, say, a doctor's office? Have you had these things? Are they allowed to do those things and deny entry to anyone that has a high temperature or checks one of the boxes to say, yes, I have symptoms, or yes, I've been around someone who has tested positive?
So we're talking about a board meeting, coming into a board meeting?
Coming into a board meeting, yes.
Okay.
Public.
My thought is you could have the sign at your board meeting. If you're not feeling well, and just kind of leave it at that, we ask that you not attend this board meeting. As far as doing temperature checks, I wouldn't go there. We have Fourth Amendment issues under the Constitution with any type of temperature check. So I think simply what you see in most public areas, whether going into a store or some other establishment, posting a sign that, if you're not feeling well, we ask that you not attend this meeting, and I would limit it at that.
All right, well, that wraps up our questions. There is one near and dear to my heart that I'll answer about how can you help advocate for extending this window? And it's from Marlene Clark, if you can see it in the chat. And yes, any information that you can share with your legislator or with us is helpful, because if we can show them data, that does change minds more than just anecdotal stories. So if you can point to increased public participation by your board members, be sure to share that with your legislator. And if you have things that you want to share with us, we will gladly take that too. Obviously, we'll keep you posted if we're able to get movement on this in lame duck, and we'll get you, there would be a brand new bill number to follow. So we'll get all of that if we get there. Do you have any final comments, Brad?
I really appreciate everyone participating in this today. Great questions. Again, still a new law, so there are likely going to be kind of new interpretations, new answers moving forward. And as soon as this is signed into law, you will be hearing from MASB notifying you of that. And I guess look for future updates going forward.
All right, and a lot of the questions are we going to be able to see the presentation in this video? And the presentation is up on our website, the PowerPoint, at our COVID-19 site, which is masb.org/COVID-19. And the video recording will also be available once we get that edited and posted as well. All of that will be available for you to review or to share with others. Thank you all for your questions today and for your participation. And as always, if you come up with more, Brad and I are always here for you. So have a great day, stay safe and stay healthy.